Hello, everyone, and welcome to today's presentation, Navigating New Pay Transparency Policies, a Look Across the U.S. Coast to coast, states and even some cities have begun to implement pay transparency policies. While this employment law trend has noble objectives like improving pay equity and employee trust, it also presents employers with potential pitfalls. During today's presentation, you'll receive an overview of these new policies and how to navigate them. This presentation will be recorded and emailed to everyone who registered. The email will come from ComplianceHR webinars in the coming days. Before getting into today's topic, I'd like to take a moment to introduce myself and our organization. My name is Samantha Greenman, and I'm the Director of Client Success here at ComplianceHR. My team and I work closely with our clients to ensure they have the right solutions to support their compliance programs, challenges, and goals. Our organization, ComplianceHR, is a joint venture between the AI technology company Neota and Littler Mendelson, the world's largest employment and labor law firm. Our goal is to simplify the complexity of employment law while helping organizations minimize costs and risks. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, I'd like to introduce you to two of our most popular solutions. First, PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a policy timeline, handbook checklists, and automated legal update emails. Next, the Reference Center offers information on a wide range of topics and insights that bridge multiple compliance concerns. It aims to help HR and legal professionals do their jobs more efficiently and effectively. If you're interested in learning more about our solutions and possibly being eligible for a free trial, we have 3 different ways listed out here for you to connect with our team of experts to have a deeper conversation with you about your compliance strategy and how ComplianceHR can help support it. We'll provide these details at the end of our presentation as well. Now I have the pleasure of announcing today's presenters, Joy Rosenquist and Kelly Cardin. With backgrounds across a wide range of employment-related matters, including pay equity, wage and hour law, and employment law compliance, Joy and Kelly are expert on today's topics. Kelly and Joy, I'll pass it over to you for today's content.
Thank you so much. We're very happy to be here presenting on this interesting and ever-evolving area of pay transparency. So my name is Kelly Cardin, and I am a shareholder in Littler's New York City office, and Joy is of counsel in Littler's Sacramento office. And we've both had the pleasure of working with these laws quite a bit over the last few years. So as most of you know, pay transparency kind of blossomed starting in Colorado in 2021, so not that long ago. And as most of you are probably familiar, Colorado passed a law requiring that pay ranges and other information that we'll talk through be disclosed in connection with postings for jobs. And this is a very interesting concept, in my opinion, because these pay transparency laws are trying to correct and cure for pay equity issues on the front end. So historically, the way that we as companies, employers, humans, tried to address pay equity issues were on the back end, right? By way of doing pay equity audits and understanding whether or not there were any pay inequities in employment that needed to be remedied. Pay transparency laws kind of came onto the scene and really aimed to correct the issue on the front end. That is, by ensuring that everyone was sort of starting from the same place in terms of pay, regardless of gender, race, and all of the other protected characteristics. They really try to get everybody on the same footing from the jump, so that way there are, hopefully fewer or no pay inequities going forward. So, as the introduction said, these laws are very noble in terms of what they hope to accomplish. I think some of the difficulties with these laws, though, come in how they've been passed in a very piecemeal way. So, Colorado, like I said, passed the first pay transparency law in 2021. And since then, other states, cities, counties, in some cases, have passed their own pay transparency laws, which in theory is fine, but the reality is that because all of these laws are similar but slightly different, it can make cross-jurisdictional compliance a complete headache for employers. So Joy and I are here to hopefully break this down for you, make it easier, and give you some strategies to help you comply without, just kind of pulling out your hair regarding all of the nuances of these laws. So the other fascinating thing that's kind of happened after pay transparency laws began to proliferate is that the expectation in the job applicant marketplace kind of shifted. So if you think about where we were in like 2019, 2020, no one really thought that they would have visibility into what employers were willing to pay for a position, right? That was kind of unheard of. Employers would say, what do you want your salary to be starting here? Or employers would say, when it wasn't prohibited by law, what were you making at your last employer? And of course, Joy will talk a little bit about this, but those kinds of questions about what you were making at your last employer are now impermissible in several jurisdictions. The thought being that, you can carry forward these pay biases if an employee was underpaid at a prior employer because of some protected characteristics. So anyway, if we look at what the expectation was in 2019, 2020, I think it's vastly different now than what it was then. Surveys have been showing that a lot of applicants now have an expectation that they have some understanding of what an employer is willing to pay for a given position. Like this is becoming the norm in a way that it wasn't before. And I think the two kind of main driving forces, well, I guess three, in my opinion, are number one, these pay transparency laws, which are requiring some companies to give the disclosure. But also that there's this sort of idea, it's not like a red state, blue state issue in the way some other types of laws are, because I think what we've been hearing and what we've been seeing is that all people kind of want to know what they could be making for a role. Like just on a human level, people want to know that they're being paid fairly. They want to know what the expectation is. So I think that there's a lot of support for these laws from people in the workforce. And then the other kind of third force that's been driving pay transparency forward, in my opinion, is that some of the third party job scraping websites, like the job posting boards, if an employer hasn't assigned a range for a position, in some cases, those third parties are going to guess at a range and assign that range to the posting, which has been another complication for employers, right? Because in some cases, the range might be too low and then employers aren't getting the candidates they want. Or the guess might be too high, in which case, they are getting applicants, but those applicants aren't going to be getting offers around where they're expecting. So I think these forces are really driving it forward. And as we've seen, there's much more legislation that's in the pipelines and that's been passed recently. States that had laws like Colorado, being the first state, have come back with amendments for more disclosure requirements. New York's kind of in a similar boat. I'll talk about that in a little bit. And then there's also a new pressing trend for pay reporting, which is another kind of pay transparency that requires companies to make certain disclosures to governmental agencies about pay, and in some cases certify that their pay practices comply with all of these various equal pay laws. So there are a lot of things going on. The upshot of this is I think we're going to be seeing more pay transparency in the future. So we're here to help.
All right, thanks for that, Kelly. As you can see, we have mapped out kind of what's going on here really as the state of the states. One of my roles here at Littler is the Workplace Policy Institute Liaison for California. So what that means, the WPI and Littler, we watch legislation across the U.S., and I watch it specifically in California and cities and counties, and then we kind of, catch on to trends and really track what's coming up. So one of the more interesting parts of our work at WPI is tracking these pay scale requirements. So as you can see, you've got states with pay scale requirements already in place in their job postings in orange.
followed by, we have several that are enacted but not in effect. So what those states' legislatures are doing is giving those employers a bit of a ramp-up time to prepare. Unlike California's law, which was enacted in September and went into effect the very next January, very little ramp-up time. You have states like Illinois that enacted their law a year ago, and it is just now going into effect here in the new year. And then lastly, there's states with pay scale legislation pending. There wasn't as much green in this map last year when we did this webinar, but the green states, the pending legislation, it's on the increase. There was also a federal bill pending for national pay transparency. As you can imagine, that's not really going anywhere in Congress. So we're going to focus really today on these outright pay scale disclosures, but first I wanted to take a moment to really explain that wage transparency isn't just about what's in the job posting. It takes many forms. So you've got your public-facing wage transparency. That is what you are disclosing to the public position pays and what the benefits are. And then you also have internal-facing wage transparency within your company. Are you advertising for your internal promotions or lockstep increases? Do people know what they will make if they bump up and promote? That's sort of your internal facing wage transparency. And then lastly, you've got government reporting. So you're disclosing to the government your pay and your demographics, and then the government is looking at those statistics to kind of look under the hood, so to speak, to see how jobs are distributed internally across your company. So when we're focusing specifically on pay scale disclosures, we've got some states that say outright in your job posting, you must disclose the pay. And then some states say, well, once you get through that application process, you can then ask, right? So once you have skin in the game, so to speak. And then lastly, you've got the states that say only upon request, if you are inquiring about a specific position, does the company have to disclose the pay that attaches to that position? So those are sort of the different variations, and we see all kinds of variations across the states. We're focusing today, of course, on the outright pay scale disclosures. So the last form really of pay transparency are these salary inquiry bands, and we will go into these a little bit more in detail this morning. But the states differ often from their localities, and that's sort of an interesting phenomenon. So why does that happen? Well, look at this. We've got 21 states and DC that have salary inquiry bans. So what that means is you cannot ask an applicant what they made at their last job and rely on that for your offer. But you also have 21 different cities and counties that also have bans in place. That's separate from their state. Localities can operate quicker. A metropolis of one area of the state may be vastly different than the politics or the policies statewide. So you look at maybe a city like Austin compared to Texas, or a city like Cincinnati compared to Ohio. So often you see cities and counties that have their own bans in place. You do have to watch out for that. So already went over the general rule, but what's the purpose of the salary inquiry ban? Like Kelly mentioned in the beginning, it's really to prevent this perpetuation of someone being stuck in that lower pay band. So an individual is supposed to be determined on the merits, whether they are acceptable for the job and what the pay will be, regardless of what they made at their last job. So that's the purpose behind the salary inquiry bans. There are sometimes exceptions, such as whether information is volunteered or whether the job has been offered already and there's a counteroffer and a negotiation process where they say, you know, I made this much in my last job, can I make at least that? And so when you get into those situations, oftentimes employers want to ask for proof, and you're in really a contract negotiation at that point. So that's really kind of the lay of the land on salary inquiry bans. We won't go too much into those today. We're focusing more on this outright disclosure. So I'm going to turn it over to Kelly to kick us off on our state-by-state overview.
All right. So state by state, we're going to start with our vanguard state here, Colorado. I'm going to caveat this by saying Colorado could be its own hour-long presentation. So I'm going to give you some high-level points of Colorado's law, but there is a lot here. I think that there's much more to the Colorado law than there is to a lot of the other laws. So we'll talk through a few salient points. So Colorado requires employers to provide a salary range, and we'll talk through what that means, and a description of benefits in job postings. Colorado is the state when, employers are going for sort of like the maximum cross-jurisdictional compliance. That's the state that you typically want to look to and try to line up with if you are going with sort of a one-size-fits-all compliance approach. I'm sure most of you understand what I mean, but for those who might not, a lot of companies don't want to take the time to sort of figure out which postings have to have which information. So they'll adopt a one-size-fits-all approach that will apply to all job postings across the country, regardless of where they are. So if you are looking to take that, Colorado is a good statute to look to, not only because it has, I'm going to say definitely the most burdensome requirements by way of disclosure in job postings, but also because it's been around the longest. There's probably been the most enforcement under the statute. So it's a good one to look to. The two main sort of highlights of this law, in addition to the salary range and the benefits and job postings, are the idea of notifying Colorado employees of promotional opportunities, and then there's also this post-selection notice requirement. So again, I'm not going to spend a ton of time here. There's a lot here that quite literally could be its own webinar. But basically, the promotional opportunities requirement under this law requires Colorado employees to notify their Colorado employers to notify their Colorado employees of promotional opportunities, regardless of whether or not those opportunities exist in Colorado. So that's kind of a mind-blowing concept in some way, where you have to be telling your Colorado employees certain information about promotional opportunities, even if those opportunities aren't in Colorado. After about 2.5-ish years, the legislature went through and re-examined the promotional opportunities requirement, and they made some exceptions to the promotional opportunities rule. Basically, now career progression and career development opportunities are excluded from the promotional opportunities. So for things that are strictly career progression, career development opportunities, they're no longer covered as promotional opportunities. So there's some sort of limiting there. But at the time they made these amendments, they also made a new amendment for a post-selection notice. And basically what this is Colorado employers are now required to notify their employees of who got the position. So you don't have to like tell anybody exactly what the person's making, but you have to say, okay, we posted this job and now this person has been hired into it. And, I think it's kind of an awkward thing potentially a bit. I think a lot of employers have been working through strategies to make it seem kind of more natural in terms of like, okay, here's who we've hired into these roles to sort of comply with the requirements. But it's an additional step that Colorado employers have to be thinking through. The other thing that I will say about Colorado, and it'll lead us to our next slide, is their enforcement of the statute. Like they've been enforcing the statute. So some agencies haven't done much with their pay transparency statute. Colorado has. And one of the areas that they have kind of honed in on when they're thinking through or when they're going after enforcement relates to the description of benefits that is required under Colorado law. So this concept is going to be carried forward into other states as well. But Colorado, in addition, as I said, to requiring the salary range disclosure, they also require a disclosure of benefits. And basically, this is sort of a high-level summary of what kinds of other benefits employees might be getting. So insurance, 401k, stuff like that has to be included in the statute. And one of the areas that we saw some enforcement around early on, which was a bit odd, was that Colorado took the position that you had to say you were giving certain leave under Colorado state law. So like their family medical leave, that had to be specifically called out in the benefits description. And that was an interesting angle in my opinion, because I think everybody thought that, what you're required to give under the law would not have to be included in a benefits disclosure. And I'm not aware of anyone, getting dinged in terms of fines or things like that. But I say it because I think that the benefits description is something that the Colorado agency looks at when they're doing enforcement. So you want to make sure that you get it right when you're putting it together. And we'll come back to it when we talk about Washington, because Washington's guidance is a bit different on the benefits, but that's a particular call out under Colorado law.
Okay, Washington. Washington gets a lot of conversation in the pay transparency, pay equity world. It is really the strictest pay scale posting and benefits job postings requirement that we see out there. And so oftentimes when we are counseling employers on nationwide compliance, we're talking about Washington, because if you want to comply with Washington, it covers a lot of the bases in your other states because there's so many requirements. So the Washington law has been in effect for almost 2 years now. It applies to employers of 15 or more employees who just has at least one person working in Washington. So it's a similar rule of jurisdictional application that we see in a lot of other states, such as California. And the job postings have to include the wage scale and a general description of benefits and other comp. And then interestingly, Washington also defines what a job posting is. And this is a struggle in a lot of pay transparency legislation, because often we just see a quick piece of legislation introduced that says pay scale must now be put in all job postings without really defining what is a job posting. Is it a semi-truck advertising help wanted driving down the freeway? Is it a sandwich board on the edge of the sidewalk? Is it a help wanted sign in the window of a business? So Washington has defined this to say the job posting is a posting if it includes the qualifications, such as what knowledge or skills you need, and it applies to a specific position, like an accountant, for example. It's a very specific position. So the wage scale and salary range that we look at for compliance with Washington, the guidance there is that it should extend from the lowest to the highest pay established by the employer prior to publishing that job posting. So if you don't already have it, you need to create it. This is also another built-in challenge. So with the pay scale disclosures, when you have this responsibility to post the lowest to the highest, or a mid-range, or a scale that reasonably applies to the position, right? Because every state's different in what they require. It de facto requires you to have a pay band. Many employers didn't already establish pay bands, and now they're in the position of actually having to establish and create pay bands. That can be a very difficult task. A lot of employers use consultants, they use salary surveys, they study what incumbents are making in the positions, they study the market, and then you put together a reasonable range and you float it out there to see if you can pick up quality candidates, and if not, then you need to, tinker with it. So Washington State has already sort of built that into their statute, saying if the range changes, you should be updating that job posting. Now, other compensation is also required to be disclosed in Washington. So this can be a very general statement. If it is a salary plus commission, you can simply say salary plus commission eligible or bonus eligible. But when you get into the 100% commission-based positions, you have to actually explain how that commission is earned, which is its own form of kind of internal calculation by that employee on what they might be able to make. So, for example, Washington has used this 5 to 8% of net sales price per unit as one example. And of course, for the more complex plans, because as we know, a lot of commission plans are not so simple as to be just based on unit, the agency says it might be compliant to provide the range of comp to be paid in the form of compensation. So if you start looking at a range of commissions that have been paid in the past, that's one way to comply. And similarly, the positions for piece rate also have to state the agreed upon piece rate. So, for example, you see the strawberry exemplar there. This is really the same rule that a lot of other states have, including California, that you can't just state this is 100% commission-based. There needs to be more meat on the bones for that job posting so people can anticipate what it might pay. So let's get a little bit into this. This is kind of the nitty-gritty on what kind of makes Washington a little bit more complicated. The general description of benefits. So all of these bullets need to be in the posting. So you've got kind of the obvious ones like healthcare benefits and retirement. A lot of other states require you to list other benefits. Where Washington sort of sets itself apart and goes far beyond is those last three bullets. So you've got number of PTO and vacation days. It's not enough to just say this position is PTO eligible. You need to state what that PTO and vacation is. That presents an issue when you are advertising to a management or an executive position that might have a different PTO allowance than an entry-level file clerk might have different PTO. So this requires employers that comply with Washington state law to really go in and kind of edit that specific posting to make that compliant. And then you're also supposed to disclose number of paid holidays and the amount of paid sick leave if it's more than what the law requires. So that can be a bit onerous to actually disclose the sick leave and the amount of PTO depending on what the state or the posting offers, that particular posting for who you're advertising for. So that makes Washington a little bit complicated to comply with, and we're going to turn it back over to Kelly to talk about New York.
Yeah, and the other thing I'll add about Washington, the statutory scheme in that state provides for a private right of action to be brought in court for a violation of the pay transparency statute. Most of the other statutes don't expressly provide for that. Washington does, and what's happened is we've seen a real scary uptick in class action lawsuits being brought in Washington state for pay transparency violations. So Washington is a good place to get it right because you don't want to be dealing with any class action lawsuits.
Totally agree.
Yep. So coming over to New York, which is where I am based, New York's pay transparency law, it statewide went into effect in September of 23. In New York, you have to do the salary range for the job, and you also have to give a description, a job description of what the job's going to entail. So we've seen like no enforcement around the job description piece, candidly. And I think for the most part, as long as you are describing the job in the posting, it's, the DOL is not going to take issue with it. The wrinkle with the New York state pay transparency law is its application to people who are working outside of the state. So I wanted to use the statute to kind of talk through how a lot of these laws relate to remote workers. So Colorado, for example, and New York City, as another example, they say that if a job can be performed in Colorado and New York City, then that job should have a pay range, even if it doesn't end up being filled by someone in that jurisdiction. And so basically what this means is if the law applies to you in Colorado or New York City and you're posting for a remote role, that role should have a job as a salary range and otherwise comply with the requirements of those laws. New York State is a little bit different, and this is where the compliance kind of gets a little wonky. So New York State says that if the job is being performed in New York, obviously the salary transparency requirements are going to apply, or if the position reports into somebody or into a manager in New York or location in New York, then the requirements of this law apply. So that's, I think, a little bit harder for employers to kind of grapple with, but the rough rule of thumb is if you have a position that's reporting to someone who sits in New York, that position should probably comply with the state's pay transparency requirements. So this is just another area where, it's like the same but different, which makes the compliance piece tough. And in New York, if you are an employer in New York City, you have to also make sure that you're complying with the New York City pay transparency law. So before New York State's law went into effect, we had a bunch of different laws. We had New York City, we had Ithaca, New York, we had Westchester County, Albany County. It was like a big old mess. The New York State pay transparency law standardized most of it, but New York City still has a few nuances that you want to make sure you're aware of and complying with if you are an employer in the city. And I think the main difference from my perspective is probably this remote piece. You want to make sure that you've thought through your approach with remote roles if you are a New York City employer. And then what I can tell you by way of enforcement is that we did see a wave of enforcement from the New York City Commission. The New York City pay transparency law is about a year older than the New York State pay transparency. So we did see a wave of enforcement probably about 9-ish months ago. And what the city was saying was like, bring your job posting into compliance within 30 days and it will be fine, you won't be fined. And they pretty much honored that, at least anecdotally, I can report that. So in New York City, while you can be fined for getting it wrong with respect to pay transparency, generally, if it's a first-time thing, the commission's just going to require you to get it into compliance and show as much, and then you should be good to go. If your head's not spinning, we'll go back to California. Yep.
Surprisingly, in this conversation, California is one of the easier states to comply with on pay scale disclosures only, but we'll talk about the pay data in a second. So overview here of California. The statute went into effect a couple of years ago, and it requires a pay scale in job postings. So in California, unlike a lot of states that require a minimum and a maximum, California has you disclosing a range that you reasonably expect to pay for the position. So that does give you some flexibility and some discretion. California does not require any disclosure of bennies, other comp, et cetera, incentive comp. I see a lot of questions in the chat about incentive comp. In California, it is just the pay scale. And then, of course, if it's commission or piece rate, you have to also disclose how those calculations are made. Now, California is different in one regard and sets itself apart because it's California. Why would it not? And that is the aspect of the law that entitles existing employees to ask their employer what pay range applies to the position they're sitting in. So this inquiry is limited to the position or the role that they're in, and the employer is required to provide that pay range. So that is an interesting wrinkle. It is leading to a lot of conversations among staff, among HR, et cetera, in terms of what's disclosed. And when people compare, of course, they may discover differences that they perceive as inequities, which may not be, right? But HR really needs to do a deep dive into their pay bands in California now that you've got existing employees asking, hey, what do I make? And then comparing it with their coworker. So the law applies to employers with 15 or more employees, at least one of which is in the state. So that's kind of how it really applies to employers with one at that point, but the law says 15. So the Labor Commissioner issued guidance on how to count employees for that. So at any point, if you have reached 15 employees and at least one of them is in California, the law does apply to you. So the pay scale that has to be disclosed in any job opening, this is another one of those statutes where I called out earlier where job posting is not defined. And in order for this law to attach, there needs to be a job posting, right, an advertisement. So there is a bit of a struggle here. We do know that it does apply to third parties posting jobs for you. So if you are using a recruiter, you have to supply the pay scale to them. The recruiter has to advertise that pay scale. If you are using a third-party website to push out your job advertisements, you have to provide the pay scale to that third-party website. So in comparison to Washington and Colorado, for example, where a job posting is covered if it includes qualifications or references a specific position, which was great that you have guardrails there. California doesn't have that. So it's actually pretty broadly worded. Now, something we're not covering today in California, because we have a whole separate webinar for it, and they're previously recorded if you want to go look them up, is the pay data reporting. So California has a separate, really quite burdensome, depending on how big you are, requirement to supply the pay bands and the demographics of your employees to the Civil Rights Department, and then separately of labor contractor employees to the Civil Rights Department. And this law was enacted a couple of years ago, so we've only had our second year. We've got it coming up again in May. So if you have any questions on pay data reporting, you can contact me and I will help guide you through that. So Kelly, how about a state I'd rather be in right now? You want to cover Hawaii?
Yes. So Hawaii's pay transparency law went into effect earlier this year in January. To comply with this law, you have to disclose the hourly rate or salary range that is expected to get, and we'll talk through some compliance strategies for setting the range in a minute. It does not apply to employers with fewer than 50 employees nationwide, and it also it also excludes internal transfers or promotions and public employees. Illinois' Pay Transparency Act, that is going into effect in January. So this is a statutory scheme whereby you have to give the pay scale and you have to give benefits. For those of you who are asking in the chat about Minnesota, that is also going into effect in January of 25. It's going to apply to employers with 30 or more employees. And like Illinois, it's a pay scale and benefits requirement. So I think, to Joy's point about Washington, my earlier point about Colorado, if you're doing the salary range and a benefits description, you are in decent shape, a good ways of the way there for cross-jurisdictional compliance. We're almost done with our survey, so back to Joy for DC.
Yeah,
it's getting too long, right? Like the more states that pass these laws.
For the Minnesota slide, for some reason, did not make it into this presentation, so we will push out an amended slide deck. But yes, that does apply starting in the new year, right around the corner, 30 or more employees, and you have to disclose salary and other comp, like Kelly mentioned. But okay, Washington, D.C. also is an interesting law. It's in effect. It covers employers with at least one employee in the district. So it's a pretty big territorial area, right? Only one employee. It doesn't even have the 15 or more or the 30 or more, just one employee in the district. So that's meant to really cover all employers operating in DC. And it requires the employer to disclose the minimum or the maximum projected salary in all job postings. So in some states, we've got a reasonable range, right? That might allow you to really target a midpoint or a midpoint up to 90%. But in states that have minimum maximum, it's going to be an interesting enforcement issue because are they really holding employers to what is the absolute maximum? So when you disclose the maximum pay in a pay range, of course, each each applicant's going to be asking for that maximum. So it's just a bit of can be an HR headache when everyone asks for the highest pay. When you've got the range, the employer can kind of control that. So DC has that issue. It also requires a disclosure to the job applicants on whether there's an existence of healthcare benefits. And you have to disclose the healthcare benefits before that first interview. So you might as well put that in the job posting, but it can be done later. And as Kelly mentioned, thankfully, there is no private right of action in this statute, like a lot of the other states. And it's enforced by the AG, and they're subject to fines. Now, DC is interesting because it's one of the few states that also has an education requirement. So it has a posting requirement. So you have to post certain section of the law in the workplace in a public area where employees assemble. So we do have those posters kind of prepared for you if you need one. We're waiting for the DC Labor Department to put out an exemplar. Okay, close by in the DMV area, we've got Maryland. So this statute takes effect in a couple of weeks and requires employers to disclose both in internal and external postings that wage range. Not only do you have to disclose the wage range, but you have to disclose the general description of benefits and other comp. So a general description of benefits could look something like, you know, healthcare, 401k, et cetera, without actually going into the more specific nuances of that. The bill also includes, this is sort of interesting, board, lodging, or other advantages provided to the employee that are a convenience to the employer in its definition of wages. What is that? So, for example, if you are a property management company and you are hiring someone to live on site at an apartment complex and you give them a rent credit, that's a benefit to the employer because someone's living on site and you're getting a credit for rent. That would go in the disclosure. That's an interesting nuance that I haven't seen yet in any other pay transparency law. The penalties range from the warning letter for the first offense to fines. And a little note quickly on enforcement. Other than Washington, where we're seeing a lot of class actions, some of these states, in lieu of a bunch of enforcement activities by the local governments or the AGs really, I guess it's limited to the AGs and the local governments, they are really amending and tightening the requirements of laws by issuing guidance and amendments in lieu of a lot of enforcement actions, right? We're not seeing a ton of suits by government entities. We're seeing the tightening up of rules in order for employers to kind of not circumvent them. So that's sort of a trend. I'm sure that will change going forward. The longer these laws are on the books, the expectation is employers have been able to comply, and you're also not going to really see these warning and cure opportunities going forward.
All right, and so then we've got two more for you. Massachusetts will take effect in July of 25. This statute is thought to be a pay range statute. Based on prior versions, it doesn't seem like you have to post a description of benefits in Massachusetts, but that sort of remains to be seen, but that's the current interpretation. The big thing about Massachusetts is this pay data reporting requirement. So we have that, Joy mentioned, in California. We have it in Illinois. Now we're going to have it in Massachusetts. And there's also some pending legislation for pay data reporting at the New York City level. So this could kind of be the next sort of hot area in pay transparency, which is why you're going to want to take steps to ensure that everything is kind of ready to go if these laws do continue to get passed, which we'll get to in a second. And then finally, Vermont, the pay transparency law takes effect also in July of 25. It's similar to the New York State law, I think, in some ways. So you have to do the range, and then there is the job description requirement. And it's also got that interesting geographic formulation where the job's in Vermont or reporting to supervisor or office in the state. So in my opinion, given that we have so many different laws and so many kind of, vagaries and then same but different, compliance can seem very daunting in this regard. But I think generally, right, if you come back to the aims of these laws and what we're trying to do, and you kind of do that, you should be okay in most jurisdictions, with the notable exception of Washington, where the class actions, that's being pushed forward by the plaintiff's bar. So be careful in that state. But otherwise, if you're making a good faith effort to comply with these requirements, I think it's going to get you pretty far in your compliance aims. So one of the things that employers grapple with, of course, is virtual work and how these pay transparency laws are going to, which laws they're going to have to comply with and whatnot. So, I think my rule of thumb and kind of my guidance here, taking a step back, I think these pay transparency laws have caused a lot of companies to really examine their pay philosophies, to sit down and think, am I a company that wants to be more transparent in this regard? Is it going to be better for me in the long run because it's going to get me better candidates? It's going to get me ahead of that, third party job posting site guessing a range. Do we want to be more transparent in this regard? And I think a lot of companies have said yes, just because the nuances of these laws are so cumbersome and confusing and hard to deal with. So if that's the case, I think what several clients I've worked with, I think have kind of gone towards is doing salary ranges and benefit postings, even if it's not required. And especially with respect to remote positions, because it's really tricky to know when you have to give the range in a posting for a remote position. I also think that in terms of where we've seen enforcement efforts, I personally have not seen anything where an agency is kind of going after companies for not posting ranges in remote positions. I think it's sort of a relatively low risk area, at least at this moment. But that doesn't mean that you don't want to get it right. And that doesn't mean that there are other really valid and good reasons to be putting ranges in job postings. All of this goes to making sure everything is in order with respect to your pay practices now, because as these laws continue to come, there's going to be, a pretty sure, additional obligations, but also because you want to make sure that you're kind of like nimble and ready to pivot if need be. So one of the things we talk about a lot is making sure that you've done your homework, make sure that you've done your pay equity analyses, think through the privilege issue there to ensure that you're comfortable with your pay practices. And once you've done that, I think it's easy to kind of come up with the range and figure out where you want to set that range. And I think when companies are kind of thinking through how they can deal with, the remote positions, think through how remote that position really is. So is this a position that truly can be done anywhere? Or is it a position that's kind of tied to, for example, your headquarters in Texas? So I think that companies have also been thinking through what it is to have a role that's fully remote versus a role that's tied to a location. Joy, I don't know if you have any other thoughts on kind of the virtual work landscape.
Yeah, it's like half the questions probably that come my way are in this virtual world because it's a conundrum. It really is. I see a lot of companies resolving this conundrum by tethering a remote position to a headquarters, to a certain location that you check in once a month to say, okay, yes, this is remote, but this is tethered to Virginia. This is tethered to Texas. So that's one way companies are sort of trying to resolve that. And then, another issue is these states that say this job posting law applies regardless if the person doesn't live here, but if it could be performed here, or if there's one person that is remote. It really puts the employer in sort of this bind of, do I need to comply with the entire state's law because one person is remote there or might be able to perform their job there who's an applicant? And that is really hard for the HR staff to operationalize and figure out how to disclose that. It's also interesting because we haven't seen a lot of litigation in this, but I suspect when we start to see more enforcement actions, we will see employers saying, that's extraterritorial. You can't have your Colorado or your Washington law apply to me. I'm sitting in Texas. So I think those cases will start butting up here pretty soon. Okay, so really, I guess the label of the slide should be, let's talk about the conversation. So job postings lead to these conversations back and forth on pay. You're at the point where you're negotiating a pay. And you've got some guidance here on what you should do and should not do. So if a candidate actively volunteers their pay, whether afterwards or in that conversation of the interview, and states a minimum that they will take in order to go to your company based on their current pay, okay, your response to that, look, we've even written it out for you. we don't set pay based on wage history and steer the dialogue to the candidate's expectations for what they want to earn. Because you don't want to say, well, they volunteered it, we're just going to rely on that. You want to say, thanks for, letting us know what your current pay is. What is your expectation for this job, for this position? So that's one way to steer it in the right direction when you're training HR staff and you're training managers on how to tackle that question that they get. So you can base your pay decisions on what you offer to an applicant based on their expectations and based on skills, education, training, experience, geographic differentials. That's a really big one. You are paying someone in the county of San Francisco much different than the county of Humboldt in California. So in a lot of the bigger states where pay is really geographically different based on region, that is also another opportunity to set the pay apart for that position. So you just really want to steer yourself away from discussing wage history. It's hard because inextricably intertwined with someone saying, well, I made this. Can I at least get that? Well, what's your expectation? So that's kind of how go for it.
No, I was just going to jump in and say, so to my knowledge, there's nothing preventing anybody anywhere in the United States right now from asking about expectations. But I often guide companies away from it just because it seems potentially problematic. And I think maybe it depends on where you are in terms of your company's pay philosophy and having ranges set. But at the end of the day, you're going to pay where you're going to pay, right? And so even if you end up paying on the lower end, I'm not sure what the salary expectation gets you at this point. So I don't know. I don't love it as a question. You can still ask it, but be careful.
Yeah, and I prefer it to really be in those follow-up conversations outside of the interview process too, right? Let's put it in that offer, counteroffer, acceptance conversation, and not in the interview where you're discussing salary. Okay, some strategies for posting your pay range and your pay scale. So we've seen a couple things work for companies. Some entities like posting that lower range initially, and then if they don't get the candidates they want, they can sort of adjust it. So you can always repost a position if you don't get the applicants that you want. Also, this is also intertwined with that conversation where the incumbent that's sitting in a similar position sees what you're posting, and it is different than what they're making. So before you post that pay band, you really need to analyze what people sitting in that position are making. How off is it? Why is it off? Let's have that conversation. Do we need to bridge the gap? Or, is there something else going on? So then you start getting into a pay equity issue, and the purpose of these pay transparency laws are to close that pay equity gap.
Sorry, Joy.
Go ahead.
I was going to say, this is like another great reason to do your homework and make sure everything's aligned, because probably one of the very last things you want are complaints from current employees based on what range you're posting in a job advertisement. So if you make sure it's all in line from the jump, I think that saves you a bunch of headaches down the road.
100%. Yeah. Another strategy is sort of an advanced strategy. So if you've already have pay bands, make sure you are now developing leveled positions within a category of employment. So we gave an HR person here as our example, HR1, HR2, HR3, or senior. So that allows you to play around with your pay bands a little bit more. Also, when you're posting for an HR1, you are not then posting the position for that senior HR3 level, right? Maybe you don't want to put that out there, and you just want to be posting the band for an HR1. We like this in California because it also helps you on that second part of the pay scale transparency law, where you have to advise existing employees with the ranges that they're sitting in. So if you have an HR generalist 1, 2, and 3, and you haven't leveled them and they all have kind of a similar pay band, you're informing that HR1 what the HR3 makes. So it's a good strategy for states that require you to disclose to existing employees the position they're sitting in, what that range is. So also, in terms of, I see a lot of questions on questions really that are more geared towards interpretation, a lot of these laws. So let me just sort of tackle that here. We basically await a few things. We await guidance from enforcement authorities on how they are interpreting a law. In California, we have guidance from the Labor Commissioner. Frankly, it's marginally useful. It's kind of restates the statute, not super helpful. And then you've got super detailed guidance from states like Colorado and Washington. So we learn from the guidance. We also learn from enforcement. We are not seeing a ton of enforcement here and opinions that are coming out as a result of enforcement. So it is hard to determine what an enforcement entity is interpreting some of these statutes language to mean or how they will apply it until we see enforcement actions. So a lot of legal advice is really given based on those two things. And then, Kelly, I'm going to turn it back over to you to talk about some more practical tips for our employers.
All right. So in terms of practical tips, I think it's really helpful to do two things. I think you want to ensure that your supervisors and your whole HR staff understand sort of that there are these pay transparency laws. So if they are getting questions about salary ranges and whatnot, they know how to handle them and they know how to route them. Some of these laws, as Joy mentioned, and some laws in other states, which we didn't get to, do permit current employees to ask for the salary range for their position. And if that's the case, you want to make sure that your supervisors understand that and are not just like, no, don't ask that question. Like, why would I tell you that? That kind of thing. So educate your supervisors, your HR people, and that's a great first step. I also think it's really important to make sure that you've thought through the sort of complaint or question process for this. So think through who is going to be handling the salary inquiry questions. Think through the team who is involved in setting the ranges and putting them in the job posting to ensure consistency. Because when you are, well, I guess when we're setting the range, one of the things you want to think through is what are the factors that you're basing the range on. So of course you want it to be objective factors, qualifications, years of experience, geography, things like that. You also want to think through whether it makes sense to make notes about why you are setting a range, where you are setting it. And this is a really fascinating issue as it relates to privilege. So you have to think about, whether it's something that you would not necessarily want to come out in an enforcement action, a lawsuit, something like that, in which case you'd want to work with counsel to ensure it's privileged. But you also want to think through whether it's helpful for you to have information written down, documented about why you set the range where you did. And if you end up going beyond the range to hire a particular candidate, why you did. So nothing in these laws prevents you from going outside the range if you need to go higher to get the talent that you want, but you want to really think through why you're doing it and then consider documenting that by reference to objective factors. And also, if you consistently find yourself going outside the range, it's probably not the right range, so you want to maybe reevaluate at that point. Where I think it probably makes sense to close it out is I think that there is so much information and so many nuances with respect to these laws. I like to take it back to the New York City guidance when it first came out. What these laws want you to do is to give a good faith estimate of what you're going to pay the successful candidate for the job. So if you find yourself kind of getting twisted or having headaches or, about where you're setting the range, where, what you're going to do for the description of benefits, come back to that. What is it that I plan to pay? What is the benefits that we're giving? And that'll get you pretty far in your compliance strategy. I do think we're going to be seeing a lot more pay transparency. So the homework about, making sure that your internal pay practices look good, you're comfortable with them, et cetera. I think that's going to pay dividends in the future, especially if we start seeing more pay reporting laws. So that's basically us at the hour. It's a fantastic area of law. I find the aims of this law very exciting and energizing. So thank you so much for your time and attention, and I will hand it back to Samantha.
Thank you.
Kelly and Joy, thank you both very much for providing us with that overview on the new pay transparency policies and how employers can navigate them best. I just want to thank everybody for joining us today. And I'd also like to offer another opportunity for today's attendees to register for a demonstration of the Navigator Suite. With all the possible pitfalls for employment law compliance, it's really critical that you don't leave your compliance strategy up to chance. Joy, Kelly, just one last thing. Was there any questions that you wanted to answer today before we wrap it up?
You know, I saw one asking about New Jersey. Yes, the city of New Jersey has a pay transparency law, not the state, just the city. So if you're operating in the city of New Jersey, you do have to disclose the pay scale and benefits. So one of our questions popped out there. I just wanted to call that out, and that's it. Kelly?
Yep, no, that's it. Yep, Jersey City has one. New Jersey State has been trying to pass legislation for a while. I'm sure it's coming at some point, just not yet.
All right. Well, thank you both very much. And thank you all to our attendees for joining us today. I hope you have a great afternoon.